Law. The module is entitled Understanding Consent. The objectives of this module are to understand the crucial term consent within the way that rape laws are drafted and upheld in courts in India. The module was written by Nishita Jha, a fellow at the New India Foundation. I'm Akash Singh Rathore from the Lewis University of Rome. So let's start by answering the basic question of what rape is defined as being in India. Legally, rape falls under the definition of sexual assault. So the broader concept is sexual assault. A person is said to have committed sexual assault if the person does any of the following things. So first, penetrates his penis to any extent into the vagina, mouth, urethra, or anus of another person, or makes the person to do so with him or any other person. This is the way that the clauses function. It tells you the act that's done, how it's done, and that it can mean either doing it yourself or making anyone else to do it. So it goes on. Rape would have occurred if the person inserts to any extent any object or part of the body, not being the penis, into the vagina and so on and so forth, or makes somebody else do it. The third clause states that rape could have occurred if the person manipulates any part of the body of another person or so as to cause penetration into the vagina and so on. The fourth clause, if the person applies his mouth to the penis, vagina, anus, urethra of another person or makes another person do that. The last clause, if the person touches the vagina, penis, anus, or breast of the person or makes the other person to do that. So what I've described and why I read it in this way is that everything that is defined as sexual assault is essentially what? Basic sexual activity. So how do you get from basic sexual activity to rape? And to understand how that happens, the concept of consent is crucial. So what transforms basic sexual activity into an act of assault or rape is that consent was not given. According to the Indian Penal Code, A is said to have raped B when they have sexual intercourse against B's will. In other words, if B has not given consent. So you see that at issue here is not the sexual activity, how it's done, with whom it's done, and so on, necessarily. What's crucial is whether the person who was allegedly assaulted gave consent or did not give consent. So in this respect, a fundamentally let's say, ambiguous concept open to a great deal of philosophical scrutiny, consent, giving, exercising free will, is crucial to a very important and increasingly adjudicated problem in India, which is the proliferation of rape and the attempts for rape laws to deal with this problem. So this module is a perfect example of a case within the philosophy of law that cross-sects very concrete and important legal questions with profoundly philosophically problematic concept, in this case, consent. So let's go into consent and see how this plays out. Now, A is said to have sexually assaulted B or raped B if B does not give consent. If B's consent is obtained under duress, for example, if A threatens B or if A threatens somebody close to B with death or violence, then A has raped B. So consent has been given, but that consent has been obtained under duress. If B's consent is obtained through deceit, then it's a very similar circumstance to duress. That means that this consent was not given in an informed manner. So the consent is nullified just as it is with duress, and the result is that the sexual activity is deemed to be rape. If B is of unsound mind at the time that she consents to having sex with A, for example, if she's drugged, if she's drunk, or if she's somehow otherwise incapable of giving considered consent, then that person is deemed not to have given valid consent, and A can be regarded as having raped B. Another interesting, let's say, way of understanding consent is whether people are capable of consenting at all. So we have this idea called age of consent. If B is below the age of consent, let's say 18, then whether she consents or not with A, to have sex with A, still A is considered to have had statutory sex. In other words, is, according to the statutes, considered to have raped B, despite the consent granted by B, because B is not at the age of consent. B is prohibited from giving that consent. And if B is otherwise incapable of giving consent, for example, unconscious or drugged, then consent cannot be assumed to have been given. Let's take an example. Let's say that you have had certain sexual experiences with a person who in this moment has been drugged or is unconscious. You cannot assume consent just on the basis of prior experiences. So in every case, consent needs to be articulated. It needs to be articulated by a person of the age of consent. It can't be forced. It can't be gotten through duress or deceit. So consent and the ways in which it can freely be given are decisive to understanding whether sexual assault has occurred or has not occurred. So what I'm trying to clarify and make a very basic point here is that rape is not necessarily about sexual activity. It is also fundamentally and crucially about the willingness to engage in that kind of activity. Now, in December of 2012, the rape and murder of a student in New Delhi caused a rupture in India's social consciousness, triggering protests throughout the country and indeed several parts of the world. This led to the Criminal Law Amendment Act of 2013, just a year later. What this Amendment Act managed to do was to nuance the notion of consent in such a way as to bring this awareness that I just mentioned, that rape is not necessarily about the activity but about the agency or the willingness to engage in it. It brought that into the scope of the law. So some of the innovations in the Criminal Law Amendment Act of 2013 was that the law for the first time recognized that sexual assault could occur even if A and B were of the same gender. Now, this is an important change because rape laws in India have traditionally been heteronormative. They've basically assumed, which is the most popular idea, that what rape is a man raping a woman. But there are many other forms that rape can take, especially if you keep in mind not just the sexual act but the idea of consent, and beyond that, that rape doesn't have to be exclusively the act of penetration. So I had read the rape law, which stated that penetration is a key element in much of the area of what we consider to be sexual assault, but it's not 100% crucial. So, for example, other kinds of activities that violate a person's consent but do not involve penetration can now be brought under the umbrella of sexual assault. For example, if A were to stalk B, attempt to disrobe B, forcibly show pornographic material to B, then we can see these as falling under various degrees of sexual assault. Now, they don't constitute sexual assault necessarily. At least the conviction rate for this kind of activity is very, very small. But if they lead to acts of penetration ultimately, then it opens up the possibility for the rapist or the accused to be prosecuted under a greater number of crimes rather than just the moment of penetration. And this is important because there are many cases where someone has committed a crime for which he cannot be convicted on certain technical grounds. But by widening the law to take into account force against will or ideas of consent, it allows the rape laws to be more properly implemented and more people to be prosecuted. The Criminal Law Amendment Act of 2013 was not the first time that this law was amended. The previous amendment occurred in 1983. Now, just as the 2013 amendment occurred in the wake of a very heinous act of rape that had happened in Delhi in 2012, the Amendment Act of 1983 was in response to a very publicized rape that had happened in 1972. In this case, it took almost a decade for the consequences to play out, so that people finally realized that the rape laws needed amendment. What had happened at that time in 1972, a tribal girl named Mathura was sexually assaulted by 2 policemen while in police custody. So like the death of the student in New Delhi in 2012, the rape of Mathura sparked nationwide outrage. Now, interestingly, the Supreme Court ruled in favor of the accused. They ruled in favor of the 2 policemen. The judges introduced a very interesting, subtle notion into the idea of consent. They said, consent doesn't need to be expressed. It can also be assumed to be implied. Now, how do you get implied consent? Well, implied consent obviously suggests that the person was willing to have sex with the alleged rapist, and while she didn't give that consent verbally, by her behavior, we can assume that a certain consent was there. What this suggests is that in the 70s, rape law in India burdened the victim of rape with having to establish that she did not give consent, rather than burdening the accused person with having to provide evidence that consent was obtained. So about a decade later, in reaction to the clearly erroneous judgment of the Supreme Court in the Mathura case, it led to the amendment of the law. The amendment was based on certain empirical facts that were demonstrated to Parliament. For example, according to the National Crimes Record Bureau, 98% of sexual assault is committed by people who are known to their victims. So it's not always an attack by a stranger on the street, the kind that would be loud, where people would be crying for help, where there would be violence and beating and so on. Since 98% of the rapes that happen in this country are rapes by family members, by friends, by uncles, and people who are known, then this idea that we have generated by the 1 or 2% of rapes, which is that these are loud, violent attacks by strangers and so on, can by no means be used as the determining mark of whether consent was given implicitly or expressly. So what this case, the Mathura case, showed, and what the 1983 Amendment Act introduced, was that we need to understand power relations when we understand consent. So the argument has been building like this. When we understand rape, the activities that we're talking about are basic sexual activities that every adult naturally engages in. So how do we get from normal sexual activity to rape? We get there through consent. But then how do we understand consent? Consent shouldn't be understood in a level playing field scenario, as though a tribal girl in police custody could just give consent to 2 upper caste policemen in jail. We have to understand that consent is itself subject to various power considerations. So the balance of power and the framework of power, which is referred to as intersectionality, is crucial to understand the nature of consent. Every one of us in society enjoys a certain privilege of power in relation to certain other people. Even the tribal teenage girl enjoys power and privilege, let's say, for example, over her younger siblings. Now, there's another judgment that is in fact ongoing and important to point out in relation to this notion of consent, power, and rape. Bhanwari Devi was a lower caste woman in Jaipur campaigning on behalf of the Rajasthan government to end child marriage. Her work offended members of the village to which she belonged and the caste panchayat, who imposed an economic boycott on her family who lived in that village. Her husband Mohanlal was assaulted by a group of 5 men. She stepped in to intervene, and at that moment she was raped by those 5 men. What does this case tell us? Well, one positive thing to come out as a result of it was that the coverage of this case led to a certain set of guidelines that are known as the Vishaka guidelines, a set of instructions for dealing with sexual harassment in the workplace. Now, we didn't have those guidelines before this case. This case, since she was working on, for the Rajasthan government, brought into popular conception the idea that we need to have a structured understanding, like we're developing for rape and consent, for harassment in the workplace. So this was one of the positive outcomes. Another outcome that was clear in understanding the nature of consent in terms of asymmetry and intersectionality was that rape, it is clear, is often a punishment meted out onto people who transgress caste norms. Now, this is a clear case of that happening. The rape was conducted in an effort to punish this person for taking steps that those who followed caste in the village felt transgressed caste norms. So what we've just uncovered through scrutiny of this case is that rape is not merely a sexual act. It is also a sexual act, but it is also some way of articulating discipline. It is a modality of punishment. So we had begun by understanding rape as basic sexual activity offered without consent, and then investigating certain cases of asymmetries of power that are important to consent. We find out that rape is itself an expression of pure power, as opposed to the expression of a sexual activity that is just meted out without consent. So these are kind of important things to keep in mind. This judgment remains undecided precisely because new elements have come into the framework that were not perceived under the amendments that were undertaken either in 1983 or in 2013. Now, the very interesting thing, both sad and interesting, about this case was that at the level of the district court, and as I mentioned, this case is ongoing, at the level of the district court, one judge actually declared that the woman was unrapeable. The rape couldn't happen. This person was unrapeable. Now, why did the judge suggest that this woman could not have been raped since she is unrapeable? His argument went something like this. Rape hinges on the idea of consent. Only a person with agency, with free will, with agency, can give or withhold consent. A Shudra, which was the word that the judge had used, a Shudra doesn't possess such agency. In other words, their consent is completely irrelevant. Since Bhanwari was a Shudra, there's no need to keep her consent into consideration. Therefore, she could not have been raped. He added in further evidence of this syllogism that he constructed, that one of the 5 accused was a Brahmin, and it is impossible that a Brahmin should want to rape a Shudra. So, for these reasons, we can see that the idea of consent and the idea of agency is crucial to the way that we think about rape. And we need to recalibrate the way that we think about rape from those cases that may hold occasionally 2% according to the statistics. We need to not think about rape according to this 2%, you know, some loud, screaming sexual act that's achieved violently by a stranger against a woman who's incapable of physically resisting. It's a far more complicated matter that has deeply philosophical considerations, considering that the idea of consent is itself subject to a lot of interpretative discretion. We've seen the Indian Supreme Court has made a very dangerous false start in the attempt to distinguish the content of consent in express and implied, but more recent legislation has done a great deal better to break down the nature of consent and what it would mean to give it. So what we're experiencing right now in India is in some way a pandemic, a grotesque pandemic of the problem of rape. And nevertheless, instead of this more nuanced understanding of why and how it happens and how to define it and how to punish it, we have a cultural attitude that tends towards victim blaming. Now, we can prove this empirically because precisely by looking back at the case in 1972. When Mathura was raped, part of the argument for her giving her consent was that she was sexually promiscuous. In other words, completely defying the aspect of agency that is clearly important to understand why and when rapes occur. The victim, the sexual mores of the victim are identified as the grounds for something like, she doesn't mind anyway, she was sexually active. Now keep in mind some of the tests that have been common in Indian penal and criminal law for determining whether a rape in fact occurred. One such test is known as the two-finger test, where the medical examiner inserts two fingers into the vagina of the person who alleges rape. If the two fingers go comfortably into the vagina of the person who alleges rape, then it casts doubt on whether that person was in fact raped. Well, why is that so? Because the elasticity of the vagina is assumed to be a consequence of a prior sexual history of the person who now alleges rape. So if this person had a prior sexual history, then it throws into doubt whether she was raped at all. Now, what does a person's sexual practices have to do with the event of rape? Well, clearly, if you understand the notion of consent and agency, absolutely nothing. But since the 70s, we've been employing the two-finger test. We've been forcing the victim to say, why didn't you scream out? Why didn't you cry? Where are your bruises? We have allowed our cultural attitude of blaming the victim to seep into the way that the law is interpreted and exercised. Thankfully, the two-finger test has now been discontinued. At least it's no longer mandatory, and the Evidence Act has updates to the Evidence Act have implemented that a victim's sexual history is not admissible in court during a trial of rape. So we've made a great deal of progress. On the other hand, the IPC, intriguingly, still refuses to recognize marital rape, and we have still refused to convict any person who has raped a male. So in other words, the heteronormative conception still remains rather dominant, and the idea that the wife is the sexual property of the husband, another cultural attitude, still remains rather dominant. So at this point, as much progress has been made in understanding and dealing with the huge problem of rape in this country, even today, after all of these improvements and amendments, the wife and the man are both unrapeable bodies. Thank you.